Good morning, everybody. Advocate Bauer, are you ready for us?
Good morning, Madam Chair. I apologize for the delay. We had a bit of an administrative mix-up this morning, but we are ready to commence, and we're going to call Advocate MacAdam, who will come and give evidence. Just as a bit of a guide, what we've done this morning is we've made a hard copy of the affidavit of Advocate MacAdam together with all the annexures. It is located in the Dropbox in folder M, and it is number 3 in the Dropbox. So it's item sounds just gone. It's item 3 in the Dropbox in folder M. I'm not sure whether that's just amplification or simply recording as well. Advise us at the back. Suppose it's the price we pay for a good day one.
If matters don't go as well as they did on the first day, you feel like you're being exposed. But
okay, I think what we can do in the meantime is, Ms. Manda, we could swear Advocate MacAdam in the meantime.
I think so.
I think we're back on.
Raymond Christopher MacAdam.
You swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth. So raise your right hand and say, so help me God.
So help me God.
Good morning, Advocate MacAdam. You can sit, you can be seated.
Thank you.
There is a file in front of you, and your affidavit that you've done.
I wonder, can we first confirm that Advocate MacAdam's oath has been recorded? Is the recording working now? Okay.
Yes,
thank
Madam
you.
Chair.
Thank you.
Okay. Advocate MacAdam, the document which is at the beginning of the bundle is an affidavit which is deposed to by you. Is that correct?
Correct,
Right.
Madam Chair.
You did that. You confirm that the contents thereof are true and correct.
That's correct.
You had prepared this affidavit for purposes of the State Capture Commission, and in the course of a consultation with me, you provided me with a copy thereof.
That's correct.
If for purposes of the presiding officers, you are currently a Senior Deputy Director of Public Prosecutions in the Priority Crimes Litigation Unit in the Office of the NDPP, and you've been there since 2003.
That's
Is that
correct.
What are your qualifications?
I'm got a BA LLB and I'm an admitted advocate.
And what did you do prior to 2003?
I have worked for the National Prosecuting Authority since 1980, save for 2.5 years where I was seconded to the Truth and Reconciliation Commission, but I then rejoined the NPA, when Mr. Ngluka was appointed as the first national director.
Now, when we talk about the OECD framework, this relates to international commitment that South Africa has pursuant to its obligations under the Convention on Combating Bribery of Foreign Public Officials in International Business Transactions. Is that correct?
That is correct.
And that convention was adopted on the 21st of November 1997.
That was adopted at an international level, but South Africa only ratified the convention in 2007, so it only became binding in South Africa from 2007.
That's correct. That was the next question.
May I just add one word of clarification, that this is one occasion when the lawmaker was forward-looking, because although we only ratified the convention, already in 2004, when the Anti-Corruption Act was passed, a section had been inserted already criminalizing the crime under Section 5 of PRECA. So it was already a crime before we'd even ratified the convention.
Thank you, Advocate MacAdam. I'm going to run through, I think for purposes of this inquiry, you can assume that the presiding officers have read the affidavit and the parties have, and I'm going to highlight certain aspects of it before we come to the parts most germane to the inquiry. So what you do is you've set out in your affidavit in paragraph 6 what the convention inter alia requires, and in paragraph 7 you point out that there are assessments done by the OECD to ensure that state parties are compliant with the convention obligations. Is that correct?
That is correct.
And then there are two kinds of review processes adopted by the OECD, and maybe you could just tell us briefly what that entails.
Certainly. The first obligation is that when the state detects a crime where its nationals contravene the convention, they are obliged to register that investigation with the OECD. If the other party to the bribe was also a party to the OECD convention, it would also be reflected on that country's matrix, and the OECD would only allow the country to close their investigation if a presentation was given to the working group and the working group was satisfied that the country had genuinely made every attempt to investigate the allegations and could not reasonably have been expected to take the matter further. So that is the first step, and that is done on an ongoing basis. But what the OECD also does is, on a regular basis, it monitors each country's compliance with the convention. That it does normally by sending a team of experts to the country to interview the experts in South Africa, to give an outline of the cases under investigation, the structures we've established to ensure that those investigations are taken further. Then that report is then tabled before the OECD, it's debated, and the OECD has a list of requirements. They are called the recommendations, and there'll be a report saying on these recommendations we're fully compliant, on other recommendations we may only be partly compliant, on yet other recommendations we've been non-compliant at all. Then in response to that report, the OECD has certain obligations. If it's concerned with the level of enforcement, it would then require at a short period of time that the country had provide a written report on steps to address the shortcomings. That written report would then be debated before the OECD, and either they would accept that there has now been compliance, but if they were of the view that there was still no compliance, they had the option to what they termed a 3-bis visit. This would mean sending a team of technical experts to the country and again assessing compliance by interviewing the officials, looking at the cases that were being dealt with. If that second on-site visit did not produce a positive outcome, they would then send a panel of OECD ministers who would then come directly to the executive of the country and engage with the executive. And that would be to bring home the extreme displeasure that there is non-compliance with the convention. The reason that there is such strict monitoring with the convention is that the assessment by the OECD is relied on by the World Bank when it determines the lending rate at which monies are loaned to states. So the OECD said, but look, you derive a financial benefit from being a member of the convention, and we will not let you profit if you don't honor your obligations. So that's why there's this extremely strict monitoring to ensure that countries do their utmost to be compliant.
So if we look at it, you say during the period 2013 to 2015, the OECD was at a phase 3 evaluation level in respect of South Africa. What is phase 3?
Okay. How the OECD processes is that when a country ratifies the convention for the first time, they have a phase 1 evaluation. That is simply, has the country enacted domestic legislation which would give effect to their treaty obligations. They then move to phase 2, where they say, fine, you now have a law, but what structures have you set up? Phase 3 is, we want to see how those structures work. So you can see each time they're becoming more and more strict on you and want more and more evidence of delivery. So the phase 3 is then a very stringent and intrusive investigation by the OECD. I've been out of the OECD, but if I'm correct, they're now on a phase 4 evaluation.
Okay. So your initial involvement started when you were approached by Advocate Gerard Nel, who in 2013 was a legal advisor in the NPA's office, and he was also employed by LAD. He's going to give you evidence later in the week, so that was his position. That's how you got involved, correct?
That is correct.
Right. And at that time, you indicated that you didn't think there was any meaningful steps done in respect of the investigation of matters. How many cases were you talking about in 2013?
There was a presentation of 6 cases.
Right. And your assistance was being sought because the report that had been generated by the OECD was highly critical of enforcement initiatives. And there was an allegation of possible political interference as a cause of that inactivity. Is that correct?
That is correct.
And that emanated from the OECD report.
That's correct.
Right. So you were part of the delegation. In fact, when we look at, you were part of the delegation that went to France, where the report was debated in March 2014, and the report that was adopted, critical of South Africa, was then adopted at that meeting. Correct?
Correct.
And what you've done is you've annexed the press statement involved in that as your first annexure to your report, and you've provided the full report as annexure 2. Okay? So that's the background to how all of this was set up. The Department of Public Service Administration serves as the convener for the OECD. Is that correct?
That is correct.
And so it's under their auspices that an interdepartmental task team was set up to address the criticisms, because South Africa was instructed to submit a written report in October 2014. And in that report they had to show improvements that was being taken based on the previous report. Is that correct?
That is correct.
And was there a representative from the SCCU involved in this task team?
That is correct. A senior deputy director in the head office of the SCCU, Advocate Michelle Ramuthi.
Okay. Up to that point, the foreign bribery cases had been dealt with by the commercial branch of the Directorate Priority Crime Investigations.
That's correct.
Right. So, what they then did, as you see in paragraph 16 of your affidavit, to address the criticisms they decided to make the investigations the responsibility of the anti-corruption task team.
That is correct.
And they specialize in the investigation of serious corruption cases. Is that correct?
That is correct.
Right. And then in June 2014, as you see from paragraph 18 of your report, you were recommended to be a dedicated prosecutor to guide the foreign bribery cases. Is that correct?
Correct.
Right. And in Annexure 3CM, you were so informed, and Advocate Mr. Ngoksana, who was then the NDPP, appointed you as the dedicated prosecutor to deal with these matters. Is that correct?
That is correct.
So, and it was on his direction that the cases stayed with you, and you were to report directly to him and Mr. Hofmeyer, a Deputy National Director of Public Prosecutions, in relation to these matters. Is that correct?
That is correct.
So you commenced working on the criticisms, and a further report was submitted to the OECD, which is annexed as RCM4 to your affidavit.
That is
correct.
correct.
That correct?
That is correct.
Right. So how many more cases were now involved besides the 6 that you were initially dealing with?
In respect to the first 6, which were dealt with in the OECD report, I had abandoned 2 of those 6 cases because we did not have jurisdiction over those matters. So that left us with 4 of the original cases, but in this short period between August and October, we had then identified a further 4 cases that had been detected. So at that stage we had 8 cases.
Right. So a report was done to the OECD, and they were reasonably satisfied at the time that an improvement was shown.
That is correct, yes.
Right. And the number of investigations had also increased. Right. If we go down to paragraph 20, if we go down to paragraph, and you've shown by way of the annexures, that if we go down to paragraph 29 of your report, you were informed by Advocate Mokgoro at the time that you should hand over the foreign bribery portfolio to the SCCU. That was roughly around the middle of 2015. Is that correct?
That is correct. The reason was that at that stage Mr. Nkosana had resigned, and Mr. Sean Abrams had then been appointed as the National Director.
And in 30, you express your approach. And can you explain to us what you then did?
That is correct, because I had received a message from Advocate Mokgoro, who is another Deputy National, to the effect that I should immediately hand over the matters to the SCCU. Now, my view is that I was performing my duties as a result of a delegation issued to me by the National Director, Mr. Nkosana, and in pursuance of a circular which he had issued. My view is that only Mr. Abrams could revoke that delegation and revoke that circular. So my position was that I could not accede to her request, and that this is a matter which should be brought to the attention of Mr. Abrams, because he would have the power to cancel that delegation if he deemed necessary.
You then had a meeting with the NDPP, and you refer to that in paragraph 32 of your affidavit, which took place on the 28th of July 2015.
That is correct.
And at this meeting was the National Director, Advocate Mokgoro, Mr. Adam, who was a special advisor, and Advocate Mogwebi in his capacity as the head of the SCCU. And you gave a briefing of what had then occurred, and the view was expressed that the foreign bribery cases should be transferred to the SCCU. You then say in your affidavit that the head SCCU leveled certain allegations against you which Advocate Mogatla confirmed had been brought to her attention. Can you briefly explain what those allegations were?
Correct. The first allegation was that in respect of a Cape Town matter, I had behind the back of the regional head of the SCCU interfered in that matter, completely overturning their project plan which they had adopted. The second allegation was that Mr. Enquiry was unaware of the fact that I was dealing with these matters and he thought they were still with the SCCU. The third matter was that the SCCU had been totally excluded from the OECD cases from the date of the on-site visit in July 2013.
And what was your response to these allegations?
The allegations were untrue. I felt so strongly about them that I submitted a detailed report to the National Director attaching numerous correspondence with his staff members, emails that I had sent to him which he had not answered, in my view, effectively refuting each and every one of those allegations.
And that is attached to your affidavit as Annex to RCM 10. Is that correct? Now, what then transpires, if we go to paragraph, what then transpired after that? What did the National Director tell you?
What happened is, I submitted my report to him. He then called me to his office and he said to me, and these were his exact words, that I must speak honestly and candidly to him. He wants to know where there are problems in the NPA and how to address them. And then I said to him, in my view, he would be making a mistake if these cases went back to the SCCU, and I specifically took him through my report showing how those allegations were refuted in black and white by emails, most of which had come from Mr. Mkwebe's own staff. And the upshot of that meeting is that the National Director said to me I should continue performing my functions as the dedicated prosecutor. He informed me that he was in the process of submitting a memorandum to the Minister of Justice recommending that I attend an October OECD meeting. And the meeting concluded because, I indicated to him the number of cases were growing. At a certain stage, one person couldn't deal with them. And he then said to me he would, at a later stage, look at getting other people to do the prosecutions because he didn't think I should be involved with the prosecutions themselves. I think he saw me more as a manager overseeing the matters. But what he did tell me is that before any final decision on these matters is taken, he would summon me to his office and he would have a personal one-on-one with me in which he would communicate his final decision on the matter.
Right. So in paragraph 34, you then indicate that the National Director shuffled the portfolios of his deputies around and Advocate Jiba assumed responsibilities for the PCLU. At that stage, you were still in the PCLU.
That is correct.
Right. You then had a meeting with Advocate Jiba, Advocate Johnson and yourself, Advocate Johnson being your immediate superior.
That is correct.
Right. And what then transpires at this meeting?
What happened is Advocate Jiba asked me to give her a briefing of what I was doing. So I informed her of my foreign bribery portfolio. But I did tell her that what had happened is since June, I was more and more being roped into all my old PCLU work. So I said to her, there had been discussions with the National Director regarding whether I continue with the portfolio or whether it be reassigned. So I said to Advocate Jiba, I need an answer on that because I can't do the foreign bribery work plus all this other work that was allocated to me. But Advocate Johnson was absolutely adamant that the matters had to go to Mr. Enquiry, and she went so far as to accuse Mr. Nkosana of committing a wrong by taking them away from Mr. Enquiry in the first place. But then Advocate Jiba said she noted everything and she would now discuss it with Mr. Abrams and come back to us.
You then provided Advocate Johnson with a report in September 2015 that went both, and you submitted that both to the National Director and to Advocate Jiba. I'm hesitating, sorry, because I'm just looking at RCM 11 and realize that you don't say in the report, or you do, coordinator, you don't specify that the Advocate Jiba is not in the address list on the top of RCM 11.
But if I remember correctly, in the text, I indicated that this report should be shared with Advocate Jiba. The report was given to Advocate Johnson, and my belief is that she would give the report both to Advocate Abrams and also to Advocate Jiba.
So you submitted it
to Johnson, and that she, as the acting unit head, would then submit it to the National Director and Deputy National.
And you sought clarification
on my role.
Right. You were then informed by Advocate Johnson in October 2015 that Advocate Jiba had indicated that it would be transferred to the SCCU with immediate effect.
That is correct.
At that stage, how many investigations are we talking about?
It's difficult to recall at that stage, but I would estimate about 18.
So sorry to disturb you, Advocate MacAdam, if you look at RCM 12, isn't that your handover report?
My handover report is dated, 1 October. My difficulty is I've been given a file which doesn't have markers showing where the one report ends.
We apologize, Advocate.
So I'm just trying to find where in the document is this report. But the cases mentioned in my report of 1 October is a true reflection of the cases at that stage.
We're going to hand you up one that has got it flagged at RCM 12, if that could assist you.
Correct. This is in fact the report in question. If I look at it, it may be that now we're talking about 22 cases.
And what did you do with those 22? Are they case dockets? Can I call them case dockets? Would that be accurate?
How it works, the ACTT works on a different basis to an ordinary police unit where on complaint a police docket is opened. Once there is what we call a first information of crime, the matter is registered at the Secretariat.
Sorry, Advocate MacAdam, the extent of detail isn't required for this inquiry. I'm simply trying to ascertain whether we're talking of 22 files or 22 dockets as one would know it. In terms of paperwork, what did you give the SCCU when you handed it over?
What I did is, this report went to the SCCU. I phoned Brigadier Mudley, who's the commander of the ACT, informed him that I was no longer dealing with the matters. So he asked me to return any dockets that were in my possession, as well as my files, because I had on each investigation opened a file containing the relevant information, my instructions to the police, subpoenas that I'd issued, etc. So all of that went to Brigadier Mudley.
And Brigadier Mudley is at SABC?
That's correct. He was at that stage acting as the overall commander of the ACTT.
So you handed everything over to Brigadier Mudley, not to the SCCU. You only gave the SCCU your handover report.
I gave the SCCU my handover report. On the 7th of October, I got an email from Advocate Malloy, who had been appointed to take over my functions, and then I gave her my NPA files to her after we had met and I'd explained what they were. They went to her.
So there are two kinds of files: the SABC files, which you returned to Brigadier Mudley, and your NPA notes and dockets and stuff, which you gave to
Advocate Baloy,
Baloy.
that's correct.
You, however, then went, you were scheduled to go to the October meeting of the OECD, and you were then informed via email communication, including the National Director, that you should still go to that meeting. Is that correct?
That is correct. In fact, the National Director said he had not cancelled my foreign bribery delegation, which required me to manage and direct these investigations, and therefore he said he instructed me to attend that meeting.
Well, then how is it that you gave all the stuff off to the SCCU if the National Director had not cancelled your mandate?
Well, as a result of what Advocate Johnson informed me concerning Advocate Jeeva's decision, I assumed that my mandate had been terminated as of 1 October, because it was very clear, you immediately hand over. I was given 24 hours to compile a handover report. As a matter of courtesy, I informed Brigadier Mudley. He asked for all the files. When Advocate Baloy contacted me and confirmed she was now the dedicated prosecutor, I gave the rest of the documents to her because I assumed that Advocate Jeeva was conveying to me a decision of the National Director, that she had discussed it with him, and what was communicated to me was the decision of the National Director. That's why I immediately complied with that instruction.
So if one looks at RCM 13, sorry to take you back, which is the email from Advocate Baloy, it says, I've been informed by Advocate Mokgoro that I will take over the OECD portfolio from you.
That's correct.
So there was communication with the SEC unit, and they in fact expected to get all the documentation from you. Is that correct?
That is correct. I may just mention is that I specifically informed Advocate Baloy that all the other files had been given to Brigadier Mudley, and I had urged both Brigadier Mudley and her to meet as soon as possible so that they could look into the actual investigation.
That is apparent from the email that you sent her on the 7th of October, which is the top of RCM 13, correct?
Yes.
Right. Now, after having been informed by the National Director that you were still the dedicated foreign briberies prosecutor, you then say you went to seek the return of your files and to establish what further transpired with investigations. Is that correct? In paragraph 40 of your affidavit.
If I understand correctly, that was after I'd returned from the Paris OECD meeting, because I believe the meeting took place shortly after the email from Advocate Abraham. So as soon as I got back from Paris, I then went to the ACTT asking for my files back.
Right. When you went to the Paris meeting in October, that was still a report back on work that you had conducted. That's correct.
What happened at that stage, there was a strategic presentation given by Mr. Governor from the DPSA, which was presented by him. My role is that other countries were presenting on their investigations, and I was there when they started mentioning the involvement of South Africa in those cases to comment on what they were saying, whether it was true or not, and to provide other information. So that was the role that I played in that meeting.
So when you came back and you went looking for your files, what were you told?
I was told that on Mr. Mkhwebe's instructions, they had been distributed to
And you then say you addressed a letter to Dr. Pretorius, who was then your immediate superior in the PCLU unit, asking him to ascertain what was going on. Did you get a response to that request?
I did not get a reply.
And that request is annexure RCM 16 to your affidavit, correct?
I will assume it, but again, it's difficult trying to page through this when it's not.
It is marked.
Oh, sorry. Sorry, I thought it was the one that I had to read. Yes, you're correct.
and then dawned the next meeting at the OECD. And by that stage, how long had you been away from the OECD files?
I had been absent from the OECD files from the 1st of October 2015, that's correct.
And you were then contacted by Dr. Solomon Hogenraad Vermaak.
That's correct.
Just tell the panel who he is.
He is, I think, a chief director in Mr. Govinder's office. That's the Department of Public Service Administration. And although the responsibility rested with Mr. Govinder, the day-to-day discharging of obligations was that of Mr. Vermaak. What he would essentially do is every time there was an OECD meeting, he would contact all the departments that were required to make a contribution and then ask them to submit their contributions to him, and it was his responsibility to then place those submissions before the OECD.
For the panel's information, one of the affidavits submitted, which is number 9 in folder M of the Dropbox, it's a confirmatory affidavit. It's a confirmatory affidavit by Solomon Cornelius Johannes Hogenraad Vermaak, who is the Director, Ethics and Code of Conduct Management in the Department of Public Service Administration, and he describes himself as the South African coordinator for the OECD. He confirmed Advocate MacAdam's affidavit insofar as the contents related to the OECD, the reports, and his involvement, in particular paragraphs 42 and 44. As matters currently stand, unless there's some conflict that arises in relation to the evidence of Advocate MacAdam, it's not the evidence leader's intent to call him as a witness. So what did, getting back to the Dr. Hogenraad Vermaak, what did he relate to you?
He provided me with a copy of RCM 17, and he informed me that this was the report which Mr. Mokgoro had compiled, outlining the status of the investigations, and which was then to be submitted to the OECD. Mr. Vermaak had a concern because the report was actually going out under my name, not Mr. Mokgoro's name. It was a report that I had compiled on the 19th of November 2014. So it was at that stage more than a year out of date. And then when I saw it, my concern is that there had been a number of comments written in red which had never been cleared before me. So I was unaware. Advocate Mokgoro never came to me, said he has to submit a report. He intends to use my report. It's going out under my name, and asked me to confirm and correct it. So if this had not been brought to our attention by Mr. Vermaak, I'd have been totally unaware of its contents.
Excuse me for a moment. I'm just looking for my copy of 17, which yes.
The one I have doesn't have the red writing, so it's difficult to see.
Donna, I'm going to give you that. That has the red lining. This is fine. Thank you. My apologies for that interruption. So if I take you through RCM 17, right? if I take you through RCM 17,
Correct.
right? And your understanding at the time from what Dr. Vermaak had indicated to you was that the redlinings had been done and provided to him by Advocate Mokgoro, correct?
That is correct.
Right. Take me through what your difficulty was with the redlinings. The first one is on page 3 of the report.
Certainly. What was admitted in this report?
So sorry, Advocate MacAdam, before we do that, the first case in the report relates to what's called the sale of farming equipment case. And we're now talking about the current status of that investigation. Maybe just for the purposes of the record, I'll identify each one by name. But given that they're ongoing investigations, we will not go into detail as to the nature of the cases, but simply the progress as at that juncture that was reported.
Okay. In that matter, I had directed a number of further investigations to be done, and the outcome of those investigations is not reflected, although this report is compiled almost 2 months later.
And those investigations are what was contained, and one can see them evident from your handover report, which is RCM 11 to your affidavit.
That's correct.
Okay. And what do you say is missing?
I had contacted the Danish authorities who would indicate that they would assist us through a mutual legal assistance request, because we had identified a Danish bank account which was involved in the channeling of bribes, and I had requested the police to do some local investigations to give me the necessary material to submit that MLA request. There was also feedback from Interpol, because this related to the bribery of a Zimbabwean government official to get contracts with the Zimbabwean government, and feedback had been given by Interpol that a Zimbabwean police unit was attending to this matter, and obviously we wanted to establish whether we could cooperate with the Zimbabwean police.
Right, so that information was not contained there. If we go to the second case, which was the telecom case.
That is correct. Again, this is an issue that did not correctly reflect the investigations that are deemed necessary. Perhaps I'd highlight the most important, well, two very important ones. First of all, this relates to the bribery of Iranian government officials. After the alleged bribes had been paid, the opposition party had won the election and now was the government of Iran. And the elected president made press statements to the fact that he had now inherited rampant corruption from the previous government, which he was committed to eradicating. And South Africa had concluded a mutual legal assistance treaty from Iran. So through Interpol, we had contacted the Iranian government, who indicated that they would entertain a request for mutual legal assistance, provided we provided them with all the evidence, and provided the request was in Persian. And at the time of my handover, I was busy working through all the material with the aim of being able to compile that request.
And what is recorded in this report is that the investigation of this matter has been put in abeyance pending the finalization of a civil action to be heard in Johannesburg. When was that civil action contemplated to be heard?
This action, and I'd interacted with the attorneys representing the two companies in concern, was only slated to take place in 2017.
And was there any reason why your investigation had to stay until, the investigation had to be stayed until the civil proceedings had been dealt with?
Not at all, because if the Iranian government assisted us, they could give us all the actual documentation relating to this contract, confirm the involvement of their government officials, check many trails, So that could continue. The other important aspect, the allegation was not only limited to bribes being paid. The allegation is that the South African company had indicated it was close to the South African government, and if it got the contract, then it could use its influence with the South African government to result in South Africa then supporting the lifting of sanctions against Iran. Now, there, I had discussed that matter with the Chief Director, Middle East Affairs of DIRCO, and he said that that matter should be taken further at a Director General to Director General level, because obviously this is highly sensitive material, but DIRCO was willing to cooperate through the senior channels.
So the next case related to the the third case related to the oil case of Petro South Africa, and the red lining is on page 17, on 7.
Can I just ask for clarification? With regard to the lifting of sanctions, what were the sanctions in regard to?
The Security Council had placed extremely stringent sanctions on Iran on its military and nuclear programs, because the Security Council was of the view that Iran was implicated in developing a secret nuclear weapons program and had denied the Security Council access to their nuclear facilities, so the Security Council could not confirm whether that was true or not. The Security Council took the matter so seriously, it was not only a prohibition on the supply of military material or nuclear material. They had identified key Iranian individuals and companies which it was alleged were involved in sanctions busting, i.e. getting those materials despite the sanctions, and there all states had been required to impose targeted financial sanctions on those entities.
The following case is the military contract with Denel. Sorry, now I'm talking about the next case is the Petro SA case.
That is correct. That I have it on page 7 at
Page
3.10. Again, this is a case where I had given extensive further investigations so that we could take the suspicion of bribery further. And that's not reflected because there were detailed matters that I had given instructions to the police on.
The note says the domestic investigation is still ongoing. Is that correct?
What had happened?
Well, now let me rephrase the question. Sorry. The note says there's only a suspicion of foreign bribery at that case, and the domestic investigation was ongoing.
Okay.
Was that correct?
We had said that the suspicion is getting stronger as a result of various interviews that I and the investigators had conducted with the senior management of Petro SA. The domestic investigation related to matters that were wholly irrelevant to the allegations of bribery. So my concern is that the bribery was the most serious charge. I think the amounts involved were in the region, and I stand under correction, of $660 million or so. So that was my concern. We need to focus on these serious allegations, and a lot of time had been given to working with the directors, the junior advocates that the regional head SCCU had made available to take that forward to beyond just a mere suspicion.
Right. The fourth case is the Denel case, and the response there is that the response from the Indian authorities was still awaited.
Again, that is a matter which it did not reflect other local investigations that could be conducted, which would possibly prove the solicitation of bribes directed to the Denel by an American company. So waiting for the response from the Indian authorities was irrelevant to that, because I had actually met with the CEO of Denel. She was very concerned about that issue, and she had undertaken to give the investigating officer access to all her staff and their files so that investigation could be taken further. And we'd also reported the allegation to the FBI, because it was an American company that was trying to solicit
But in
bribes.
fact, at that stage, the Indian leg of your investigation was closed, as you reflect in the...
That is correct.
Your next case is the bribery of the Lesotho government officials by a Middle East company, which you see the red line on page 9.
That is correct. Again, it was a concern because the investigation of this matter has been put in abeyance pending the finalization and discussions from mutual legal assistance between the relevant countries. What had happened is, after the 1st of October, I had been contacted by the Lesotho prosecutor saying that they had found more evidence. Previously, I had facilitated a video conference between myself, the Lesotho prosecutor, and the prosecutor in Israel, and the Lesotho prosecutor was calling for another similar conference. The Israeli prosecutor also had indicated that there's more developments on their side and was supporting the call for a conference. So I said I'm no longer dealing with them. I had referred the matter to Advocate Beloy for her attention. They came back to me, both the Israeli and the Lesotho prosecutors, saying they were getting no response. So I took their emails and again forwarded them to Advocate Beloy with the suggestion that she attend to this matter.
The next investigation relates to the Paramount Group, and I understand that is correct.
That is a correct reflection of the status.
The 7th case is the cases awaiting placing on the OECD matrix, and the response there is that a full forensic report had been received, and it indicated that although there was a case of corruption and irregular expenditure, there was no evidence that pointed to foreign bribery. Is that correct?
That was not correct. There was a provisional forensic report recommending that a full forensic report be commissioned, and that the DPCI conduct a corruption investigation. And the case was on the matrix for the United Kingdom because the evidence was that a British company had bribed South African government officials to obtain contracts relating to a South African state-owned enterprise.
The next case related to the bribes paid to the Iraqi ministry officials by Australian companies using South Africa as an intermediary.
This again, it wasn't intelligence information. There'd been a fairly comprehensive report detailing the matter, and the Australian police had extended an invitation to the South African prosecutor to go to Australia, meet with them to review all the available evidence. So this was already tabled in the meeting in June with Mr. Abrams. So I'd already expected that there would have been movement on that.
You then, after the signature, which was your signature, has been in 2014, after that was in red written, other cases managed. Could you briefly tell us a little bit about those cases?
Okay, the first one is security and notes printing, where it says that no investigation has been conducted, however received a request from mutual legal assistant and the request is being processed. I had actually written to a senior member of the ACTT saying that that request disclosed complicity by a South African, and we should not only attend to the request for mutual assistance but investigate the involvement of this person over whom we had jurisdiction.
The next one is the Net 1 matter. This emanates from the Constitutional Court judgments in relation to the SASA matter, And whilst it is correct that the judgment itself makes no findings of corruption, what was the cause of, or what is your concern over the decision taken not to decline to prosecute?
My concern is the following. Corruption has never been proven in any court, but the tender was handled by SASSA has been proven to be irregular. No finding of corruption was made by any court in South Africa. The issue at stake was the fairness of the tender process. Now, this report is written in December 2015. Already in 2013, the Constitutional Court had unanimously concluded that the non-compliance with the tender procedures constituted a violation of the Constitution. The Constitutional Court also accepted a submission by Corruption Watch to the effect that when you have irregularities of this nature, there is always a red flag for corruption. So in my view, the Constitutional Court craved an investigation. And if we look at all the controversy that has surrounded this matter, what is furthermore is that the Americans had submitted an MLA request relating to certain bank activities. The company that didn't get the request had filed a report under Section 4 of the Corruption Act, reporting corruption which had come to their attention. And a police officer who is not of the ACTT had phoned me saying that somebody had contacted him with also information of corruption. Now, I'm not saying...
But isn't it so? Because if you look at your handout report at that stage, what was clear was that the Americans were in fact investigating the allegations in the American end.
That's correct, yes.
The next one is the Tanzanian facilitation payments case.
That appears to be a correct reflection of the facts of that case.
The MTN Cameroon matter. There was no file. There doesn't seem to be any...
Now, what had happened there is I had sent an email to a senior member of the ACTT when this matter came to my attention, requesting them now to register an inquiry and so that we could start looking into these allegations.
But the Itachi matter?
Again, this is important that I was present at a OECD meeting where America had reported that Hitachi America had pleaded guilty to paying bribes to South African officials in order to get the contracts for the various power stations that were being built to address our shortage of electricity. And the chairperson of the working group had said that he required South Africa to properly investigate our side of that corruption. And I'd actually contacted the ACTT and said, you know, register an inquiry so that we could start looking into it. We'd also contacted the FBI to find out more information on the American case.
So it's not correct that no investigation was initiated?
It may be correct that it was not initiated, but I had specifically requested that be done sometime previously.
On the Quanta Service Incorporated case?
Again, that is a matter where I'd said register an inquiry because asked the Americans to give more information about the matter. It was a case where they alleged that there was a South African involvement to their investigation.
And in fact, on your report, the US Security Exchange Commission, it was being investigated in America.
That's correct, yes.
The second last one is listed as Bombardier, which was a Canadian company.
This is correct. This is the company that supplied the Gautrain locomotives, and Canada is a member of the OECD, and they had it on their matrix on the allegation that bribes had been paid relating to the Gautrain. Now, I had brought this to the attention of the ACTT. They told me that they thought they already had a pre-existing investigation, so they were going to check, and if that's so, what we had from the Canadians would be added to that, failing which we would have to look at then doing a new investigation.
Okay. And the last one is the arms deal related case. And the response there is there was no basis for investigation on any matters relating to the arms deal.
That is also not correct. I had on 2 occasions been required to give presentations to the OECD regarding these matters. On each occasion, I'd explained to the OECD that there was a commission of inquiry headed by Judge Soretti into these matters, and our view is that we would wait for the findings of that commission before deciding to investigate. The other countries were asking for deletion of the cases, and the OECD said no. Until they have the full story from South Africa, they're just not going to accept the word of that country that it didn't pay bribes. Now, what had happened is, the one case related to a German company, Ferrostal, which was alleged to have paid bribes to get the submarine contract for the South African Navy.
We don't need all the,
Okay.
the detail. Essentially, Advocate MacAdam, if one fairly looks at your handover report, the amount of detail you've provided to this inquiry isn't obviously evident from the handover report that you provided. How would you have expected the SCCU to know what you've just relayed to us? Is it apparent from the docket?
You know, the brevity of my handover report is due to the fact that I was given less than 24 hours to compile it and give it to Ms. Johnson. But I had met with Advocate Baloy. She acknowledged having receipt of the report, and I said to her, my door is open. You need any information that we're in the same building, you come to me, I'll help you. I'd also urged her and Brigadier Mudley to sit together so that between the two of them, they could go through these cases and pick up where I'd left off. And if they weren't clear what I was doing or things were missing, come back to me and I'll explain what the position was.
Okay. So when this report, which we've just gone through, is brought to your attention, and we at paragraph 43 of your affidavit at this stage, you then submitted another report to Dr. Pretorius. Dr. Pretorius was at that stage in your head of the PCLU. Is that correct?
That is correct.
And that report you find at Annexure RCM 18 of your affidavit. And you informed him of some of the concerns that you raised in relation to the red annotations.
That's correct.
Right. Did you get a response?
I did not.
What then transpires?
I was authorized by the National Director to attend this OECD meeting in December. And prior to us giving the presentation on the status of investigation...
Is this now in Paris? When
this
you
is
say
in
prior?
Paris. Because this came to our attention, I think, a day or two before we were due to leave. So when we were in Paris, Mr. Governor, the most senior government official responsible for reporting to the OECD, Mr. Vermaak, Mr. Mokgoro and a Colonel Mshlongo from the ACTT were all present so that we could have a pre-meeting to decide how to deal with our feedback.
And you then relay in your affidavit that Mr. Govender indicated that it would be highly embarrassing to place this altered report before the OECD.
That is correct.
And then what followed?
What happened is that both Mr. Mokgoro and Colonel Mshlongo informed Mr. Govender that Mr. Govender should then inform the OECD there was no progress and put that officially on record before the OECD.
And then what did Mr. Govender respond?
He said that was unacceptable because we had always been going to the OECD and we could show on an ongoing basis we were making progress on these matters, and that had not only been well received by the OECD, where we were dealing with other countries such as Portugal, Germany, etc. Those countries would also confirm our positive involvement. The Israelis went so far as to say that as a result of our work, they had detected this crime which they would have otherwise been totally unaware of.
And it was then agreed that you would give an oral report of the progress made up to just when you were removed from it, and there was then agreement that you would do so.
That is correct. So I did make the presentation. I think I had last given a report to the OECD in March 2015, so this report covered the period up to 30 September 2015.
And you then subsequently provided Advocate Mokgoro with a memorandum of the events that had occurred, which is annexed to RCM 19 to your affidavit, correct?
That is correct.
Right. And you highlighted the lack of progress that had been made since the files had been removed from you.
That is correct.
Did you get a response from him?
I did. I think it's attached to my affidavit as one of the annexures. I must just look for. Yes, I have it as annexure 19. It's my letter
20 is
of
his response.
yes.
And his response is effectively that the foreign bribery cases are the responsibility of the SCCU. Accordingly, I would not expect anything pertaining to them to be done with my knowledge. Why did you understand that to mean?
Well, it raised this dilemma that we're facing, where he claims he's now dealing with them, but the national director says that my authorization still stands, and my authorization was to exclude, other business units from dealing with them. Because even at that stage, despite the fact that I'd written several letters to Advocate Pretorius saying that the national director must resolve this dilemma, who's dealing with them, we had not a response for the national director, and in my view, his email to me that he has not cancelled my appointment still stood.
He then further tells you that indeed the national director advised that at the request of Mr. Govender, he agreed that you could attend the October 2015 meeting. Further, that paragraph 9 of your report, to the extent that it creates an impression that there was no progress with the investigation of these matters, does not correctly reflect the true position, and he found it to be unacceptable. Did you hand over the files to his deputy by that stage?
All the files had been given to Brigadier Mudley, which outlined exactly what I was doing on the matters, and I'd urged Advocate Baloy to then meet as a matter of urgency with Brigadier Mudley, and if once they had met, they needed clarification, etc., my door was open. So in my view, there is no reason why the SCCU, as of the date of our report to the OECD, would not have been aware of all the matters, been able to take the matters further. I may mention that most of my investigators were colonels, so it was experienced police officers, very professional officers, and I can't see why further investigations, as I had identified, could not be carried out. If they didn't agree with the way I was dealing with the matters, they could given different directions. So I cannot, accept what he says there, and I find it strange that if there had been progress made, why he had not firstly submitted a report himself setting out all these further investigations, and why he could not have made that presentation himself, because I was having to come in literally to save the day.
Advocate MacAdam, the final paragraph in that is you are reminded in seeking clarification of your position from the national director to do so via your unit head, and your unit head is supposed to go via the office of Advocate Jiba. Is that correct?
What the position is, I report to my unit head. He has a discretion. Does he deal with Advocate Jiba, or does he deal with the national director? When Advocate Pretorius took over, I saw on several occasions that national director would phone him in my presence and give him directions on how to deal with matters. On other occasions, I would go to my unit head and say, well, how do you propose we deal with the matter? He'd pick up his cell phone, immediately phone the national director and say, what do we do? And he'd get an instruction. So my attitude would be at the discretion of Advocate Pretorius Does he go directly to the National Director? Because it would appear he had an advocate open door. But as Advocate Jiba was the Deputy National responsible for our portfolio, he would also be entitled to go through her, and then she would go to the... But my duty stopped at bringing the matters to the attention of my unit head.
And that you did in 2 further correspondences, which is annexed, marked RCM 20 and 21. Is that correct?
That's correct.
And you also indicated what had been relayed to you by Advocate Mokgoro in those memos.
That's correct.
Right. You at that stage indicated to your unit head that you had been cut off from OCD matters and you would focus purely on PCL, your work.
That's correct.
And you had nothing further. Wait, hold on. You never received a response for your request for any meeting between yourself and the National Director. Is that correct?
That is correct.
And at no stage did any member of the SCU approach you asking you for any advice on the foreign bribery cases?
Not at all.
The next subsequent report, which is annexed at RCM2, which is then 3 months later, gets provided to you. Right? And you then detail in paragraph 49 that the report raised serious concerns about the lack of active enforcement and limited progress. And that only 11 investigations had been conducted out of 17 allegations, and that few investigation tools were being used in the majority of the cases. Was that regarded as a serious criticism from the OECD?
I took it to be so because they said one of the options, if there is not a satisfactory response, would be a 3-bis visit to the country. I think that was set out in their document.
And you were then later provided with a copy of a letter which had been written to the National Director by the Director General DPSA, informing him of the concern and the fact that feedback had to be required to be given to the OECD by March 2017. The 3-bis evaluation seemed to have become far more evident or likely to happen at that stage. Is that what you'd been told?
That's what I've been told by Mr. Vermaak, who provided these documents to me.
Okay. You subsequently had been contacted by the Asset Forfeiture Unit in 2017.
That's correct.
Who contacted you?
It was investigators in their office. I can't recall names now, but they were asking for more information on the cases that I had been working on, and they were surprised to learn that I had been taken off these cases as at 2015. So I had to then go and check my files and send some emails, communication. I had to refer them to the investigators. In some instances, I still had my emails sent to the investigators, which I then forwarded to them.
So in sum, Advocate MacAdam, if one was to sum up your evidence germane to the inquiry today, what would that be?
That we were back to square one. When we had started in 2014, there was no proper enforcement, and now we were exactly in the same boat, looking at the concerns of the OECD, because it has slipped back now to 11 cases, and in very few cases was use being made of legal tools. Because at the stage when I was taken off, we were looking at mutual legal assistance requests to various countries. I'd issued a number of Section 205 subpoenas. The one matter, we had invoked POCA to compel the Revenue Service to supply us with information.
You've detailed some of those. Are these the kinds of investigations that I understood from Advocate Ramaiti, or what you call prosecution-guided investigations?
That is correct, because the sole reason I was involved is because the PCLU, by proclamation of the President, we must not only do prosecutions, we specifically directed to manage and direct investigations. So my involvement was to work directly with the investigators to guide them every step through the investigation, and also to ensure that all the legal tools are properly invoked at the right stage. So it was a whole hands-on approach, working with the police, so we get to the point, either yes, there is a case, or no, we can go to the OECD and say, despite diligent efforts, we cannot prosecute or take the matter further.
Thank you, Advocate MacAdam. I've got no further questions.
Can I ask, as a point of clarification, you say when we were now in the same position that we were in 2014. What do you mean by that?
Well, the criticism, and if you look at RCM2, is the assessment of the OECD on the 6 cases that were presented to them, where they said there is no movement on those cases. In 4 of the 6 cases, there was no involvement by prosecutors. In the 2 cases where a prosecutor was involved, in the first case, they'd never ever detected a possible foreign bribery, despite the fact that they'd been dealing with the case since 2012. In the second matter, the prosecutor had made a decision based on the wrong act. He was dealing with it under PRECA, but the crime was committed under the Corruption Act, where we had actually no jurisdiction over the offence. So instead of trying to investigate the matter, it should have been no jurisdiction, end of story. And then if we look at the comments in red, either there was...
Can I interrupt? Because that's where I wanted to go. This report, RCM2, is dated March 2014.
That's correct.
But in 2015, you then make a report, the one that has been taken through. So I would imagine, what I'm trying to understand is, where are we post 2015? When you say we're at the same position as 2014.
What we're seeing, I can't comment what happens in 2016. I was totally divorced. But if you look at that report, either no investigations are being done, or there is a denial that the police have any knowledge of the matters, whereas in respect of each of those cases, the police have been informed of the matters and been requested to open an investigation, and clearly steps could have been done to take those investigations further.
In your view, would you then say that the will to get these investigations going was lacking where? At the bottom level, or at the level of the people sitting in the senior position between the NDPP and yourself?
It rests at a senior level. It's the responsibility of senior management to identify we are dealing with serious cases and to make sure that those cases are properly addressed. So top management must say, these are serious matters, we must allocate senior prosecutors to them, we must ensure that they're managed, we must work closely with the police. If there are problems with the police, we must take it up through our management structures. Because in this matter, there was an entirely passive role taken. The impression I get, it was left to the police themselves to decide what to do or not to do. Because specifically, when the 6 cases were presented to the OECD, there was a senior deputy from the SCCU present when those presentations were given. The police officer presenting it was severely criticised by the OECD because they said, you're doing nothing. You're actually just sitting back, relying on the other country to do the work. Because in a lot of those cases, police said, no, there's an investigation by another country. We must sit back and let them conclude, instead of saying, on what is available, there's more than enough to open our investigation and start doing things ourselves. And this was a concern that the prosecutor sitting in that precedent was passive. She never came and made contributions explaining what the situation is, what the police are saying is not correct. Here they are playing active roles. And literally nothing was done on that matter. Like the Denell case, I think went back to 2005. And no local steps had been taken to investigate the matter since 2005. the MTN case, MTN had filed a Section 34 report. It had been received by the police. Nothing had been taken to investigate the allegations further. The Zimbabwe case, again, apart from executing a MLA request on behalf of the Portuguese government, which simply alerted the accused to the fact that he was under investigation, nothing further happened there.
Thank you. Advocate MacAdam, would you? In fact, you do mention that investigation and or enforcement of decisions with regard to these matters are viewed or are part of prosecutorial duties.
That is correct.
Yesterday, we so to say articulated, or Dr. Ramaite articulated the notion that societal or social interests or social issues generally become part of the factors taken into account when a prosecutor, whether at local ground level or leadership level, exercises her or his discretion to prosecute or not to prosecute.
That is correct.
The way I understood him was that it is one of the factors to be taken into account. Now, if you look at the OECD report, one of the concerns that they raised was the lack of either investigation or follow-up by South Africa with regard to these cases, was, as they say, political or economic considerations. What is your view? Do you think that is the correct assessment by the working group of the OECD?
What the convention does is relate to the bribery of government officials to get lucrative contracts. Now, if you look at the OECD, probably the most cases come from arms deals, because countries are prepared to pay billions to get weapons. And consequently, the OECD has a very strict provision, I think it's Article 5, that said you are not allowed to take either economic or political considerations into play when you decide not to investigate. So you cannot say, but our army is dependent on those fighter planes, so if we now investigate the supplier, we won't have airplanes to defend ourselves, so on that basis we will not investigate. They say your obligation is to investigate that case irrespective of what the political fallout is. It's the same thing with the economy. They say, but South Africa needs that contract with Iran. You can't say, well, then we mustn't investigate the corruption because that will cause loss of money for a company. And this is very strict. This is where most countries, if you go onto the OECD, they have reports on all their member states. And one of the things that they put the most focus is on Article 5. Now, the conclusion that the OECD reached, as we said, look at who the suspects are. Denel, state-owned enterprise, the prime supplier of weapons for our army. MTN, a blue-chip South African country trying to get into the international market. Wouldn't South Africa want to protect MTN, because if they lose these foreign contracts, it's ultimately going to prevent foreign money coming into our country. Petra SA, the state-owned enterprise, responsible for getting our oil. Same story if it's dependent on our oil, and we should just turn a blind eye to the corruption because that might increase the price of petrol. So that's why they say when you approach these matters, you are not allowed to look at either the political or the economic impact that you're in. Your job is to say, is there corruption? And if the corruption is there, you must prosecute it to the fullest. And Advocate Nell, who I believe is testifying later this week, will be able to confirm that he had to amend our prosecution policy when South Africa ratified this convention, because there's a provision that we could actually decline to prosecute for economic or political reasons, and that had to be removed so that we could comply. And I believe it's essential. Every case that a prosecutor does, I believe your sole right has a crime being committed, must it be prosecuted, not to look at what political or economic consequences you have. And that is why you have prosecution independence, to ensure that you do not succumb to these influences.
There would be a difference between basing a decision to prosecute or not to prosecute on political, let's say for example, political considerations, and in another set of circumstances regarding political and or economic circumstances as a factor, only a factor among others. Can a prosecutor do that? Or ought a prosecutor completely, totally disregard political and or economic factors?
I believe we are obliged to do so.
To disregard.
That is correct.
Thank you. But in your experience, do our prosecutors, or are our prosecutors, one way or another, faced with political and or economic pressure when they make decisions, in this case to investigate or to permit an investigation, to enforce a decision? Is it the same? And do you think our prosecutors have that experience?
I certainly have experience of that. For many years I was involved in the political violence in KwaZulu-Natal. The minute you started an investigation that targeted a political party, in certain instances the national director would tell me the leader of that party had phoned the president and told the president, get rid of MacAdam and drop that investigation. At another level, there would then be protest action at the court, everybody demanding that we drop the case, release the accused. At another level, politicians would start with campaigns saying that the investigator, prosecutor are politically biased, pursuing a prosecution just to target their political opposition, or we're using our powers just to eliminate a political organization out of the equation. So that surfaced prominently there. I've been involved in cases where we have had a profile companies involved. Then they come with a formidable team of lawyers trying to influence you just on what they say, drop the case, and you say, sorry, we'll drop the case only if there is no evidence. So that has occurred in my experience. The other matter I think it's important to bring to the attention of the court is the Zimbabwe torture docket, where an NGO asked the police to investigate the torture of the political opposition in Zimbabwe. Now, one of the reasons why the National Commissioner declined to conduct that investigation is he said that President Mbeki had been appointed by SADC to act as the mediator in the conflict between ZANU-PF and MDC. Now, if this complaint was to be accepted, that would be the end of his role as a negotiator, and that's why they're not investigating. And that decision was severely criticized, not only by the High Court that rejected it, but also in the subsequent appeals to both the SCA and the Concord, and the Concord was very clear. It said that the only basis upon which you can decline to investigate an international crime is if the country where the crime is committed is itself dealing properly with the matter. And they went further and say, we are obliged, where the country is taking no obligation, we have to investigate. So another case that illustrates this matter is the al-Bashir matter of the president of Sudan coming to South Africa for an AU conference when there's a warrant of arrest issued for him by the International Criminal Court. And government was severely criticized in the SCA and the Pretoria High Court for failing to give effect to that warrant.
Thank you. Advocate Masuku.
Madam Chair, we have agreed between the parties that I'll commence cross-examination
today.
today of this specific witness.
This specific witness, okay? Then the witness is yours.
Thank you, Madam Chair. Mr. MacAdam, I just want to confirm something with you. As I understood your evidence towards the end, you've not been involved with the investigations relating to these foreign bribery matters since the end of 2015.
Actually, until 30 September 2015.
So you have no knowledge what has happened in these matters since then?
No.
So then I would like to join the question from the panel, and that is, when you said we are back where we started, we are now in January 2019. I just want to understand, when you say we are back when you started, are you referring to now, or are you saying we were back when we started in December 2015?
No. What I meant to convey is that when I looked at what was written on my report in December 2015, we were back in the situation of 2013-2014, where the OECD had criticized the country for a lack of enforcement, because when I looked at the remarks and read, they were not addressing key investigations that I'd already identified, and in certain cases it was indicated that the police were unaware of matters, although I had communicated with the police and told them to open inquiries on those matters so they could start receiving attention.
Okay, so you mentioned the Section 3 bis as a tool that the convention could use to get states in line, and that we had been threatened or could be threatened with such a 3 bis investigation and visit in your evidence.
Correct.
As to the best of my knowledge, as far as I know, my instructions are that has never happened.
That is correct.
And South Africa hasn't been affected in its financial situation because of an OECD complaint.
That is correct.
So the scenario that you feared in 2015 hasn't come to pass.
Well, the door is open. I believe there is another assessment by the OECD in March this year, but what the outcome of that assessment will be, I cannot comment on. So the chapter's not closed with.
No, we all know things can still happen in the future, but I'm talking about what you have knowledge about and where we stand today.
Yes, as far as I stand today.
Okay, when did you accept that you were no longer in charge of the OECD files?
When I received a instruction from my unit head on, I think, 1 October 2015 to immediately prepare a handover report and to hand over to the SCCU.
Because in your evidence and in respect of that aspect in a number of the documents and reports you've referred us to, it seems that you did not accept that was the situation for quite some time.
Well, what muddied the waters was the email by the National Director, I think of the 8th of October, saying that he had not cancelled my appointment, which then required me to deal with these matters and his instruction specifically then to attend the OECD meeting, because that he is the person who decides what I do or not do. And here was an instruction from him to continue with my work.
Okay, we'll get back to that. Let's just get back to the instruction that you are no longer in charge of this. That you said came, apart from the email, from a meeting where Advocate Jiba also informed you of this fact. Is that correct?
No, I was at no meeting with Advocate Jiba where she informed me that I'd been removed from the cases. I was informed by Advocate Johnson that she had had a meeting with Advocate Jiba and she was conveying what Advocate Jiba had decided.
And you then also made the statement that you accept that if a Deputy National Director gives such an instruction to you, your unit head, that must have come from the head of the NDPP itself.
That's correct.
So why did you doubt that later?
Because of the email from Mr. Abrams saying he has not cancelled my delegation as a foreign bribery and I must continue and in fact go to Paris, because that de facto reversed what Advocate Jiba had decided.
Well, was it Advocate Jiba's decision or was it the NDPP's decision, Mr. Abrams' decision, that you no longer are on the job?
I was informed by Advocate Johnson that it was a decision taken by Advocate Jiba.
I'm sure Council will deal with that in due course. Is it not correct that when you say you were informed that you had to attend the October 2015 Paris meeting and at the same time in the same correspondence you were also instructed to attend the December 2015 meeting as a delegate, that was all that meant? It just meant that you're still authorized to represent us as a delegate at these meetings. It does not mean that you are now still in charge of the investigation.
No, Advocate Abrams' email was to the fact that he has not cancelled my delegation. That placed me in charge of these matters. So my view is that I was then still the dedicated prosecutor, leading me to write these letters to Advocate Pretorius to say, clarify the position, because we now have the dilemma, I'm still in charge, but I'm cut off from the cases. I mean, Advocate Abrams, I know him since the 1990s when we worked together in KwaZulu-Natal. He would have clarified and said, you're no longer the dedicated prosecutor, but we'd like you to be there because of your historical knowledge. And he'd have made it clear. And I had had 2 meetings previously with Mr. Abrams where he'd made it clear to me he wanted me to continue with these matters.
Just to go back one step and to understand exactly how the December meeting operated, you said there was a group who were in charge of these matters under the Department of Public Service.
Which meeting? Is this the December 2015 one?
The
There was
December
one in March.
2015 meeting in Paris.
It was facilitated by the DPSA, Mr. Govender, the Deputy Director General, for Mark, the Chief Director, myself, Advocate Enquiry, and Colonel Baloy. And I think there was also Mr. Ngiba, who was responsible for mutual legal assistance in our office. That was the group of persons who attended.
And why did that? Do you know why that specific group attended?
Because it was the feedback by South Africa on the progress on investigations that had been conducted since the last feedback had been given.
No, not why you were there, why those specific individuals were representing South Africa there at the meeting.
Advocate Mrebe was attending as the head of the SCCU. Advocate Ngiba was in charge of mutual legal assistance, and often at these debates there are complaints by the other countries that their requests aren't being acceded to, and Govender and Vermaak were the people responsible for interacting with the OECD.
And you spoke earlier about there being a group that had been established in 2014, and at that stage you mentioned the Department of Public Service report. You start off by referring to the report of October 2015, and that the department, that this was under the auspices of the Department of Public Service Administration.
That's correct.
Could you just explain to us how that worked? Why were they in charge of this?
They are the convener of the convention. What happens is a minister of government signs a treaty. In this case, the minister, DPSA, signed the treaty, therefore DPSA was responsible, and what DPSA would say, whereas we now need inputs from other departments, for example, NPA, Police, Revenue Service, Auditor General, National Treasury, they will then approach those departments and ask them to provide their inputs, and they would then facilitate the process. So all these reports are put together in a manner that they don't contradict each other or cause problems.
And then, when did you start working on these matters exactly?
What happened is, that was when I received my delegation from Mr. Kasana in August 2014.
Where were you employed at the time of this delegation?
At the Priority Crimes Litigation Unit in the Office of the National Director.
And what did you do then after that? Did you continue doing your work?
No, I was removed from my other duties in the PCLU so that I could focus full-time on these matters.
And did you have investigators in each matter? Explain to us briefly how each, we couldn't decide apparently if it was a docket or file or how you wish to describe it, but how each matter was dealt with?
The procedure with the ACTT is different from an ordinary police station. What happened is, on any information about a bribery matter, they had a secretariat which would register what they called a pre-investigation file. The secretariat would gather more information about the matter. There would then be a ACTT principals meeting, and there would then be a presentation of the case, and it would then either be adopted as an ACTT matter, in which case it would go over to a full investigation, an investigator would be appointed. The ACTT's mandate required that one crime be a crime of corruption. So if you had a matter and the operational meeting decided that you only had fraud or theft or money laundering but no corruption, then it would be referred to the commercial branch and it would not be an ACTT matter. And then, you know, the investigation would be monitored. How far does it go? Does it go to the point that you're going nowhere? Then there would be a meeting of the ACTT where it would be agreed to terminate the investigation. Obviously, if it went to a prosecution, it would then be dealt with through that channel.
And then you did this until the end of September 2015.
That's correct.
And after that, you didn't get involved in any further investigation.
That's correct.
So the period that your complaint relates to is effectively for the months of November and December of 2015 as to the period in which everything went back to the start, according to you.
That's correct.
So the entire disaster happened in those 2 months.
Well, I'm saying that key investigations were not being done, and secondly, the police claimed to have no knowledge of matters that had been brought to their attention already and should at least have been opened as a pre-investigation. That's what I'm saying.
Okay. Mr. MacAdam, would I be fair, having listened to your evidence and having read your reports, to say that you were extremely disgruntled at being removed from your position?
I was not disgruntled. I was disappointed at the fact that I was removed in the manner that it took place. I had had 2 meetings with the National Director, culminating in the fact that there would be a one-on-one with me. So I expected that there would be a face-to-face, if not with the National Director, but with Advocate Jebus. So I was disappointed, but I accepted the decision.
I don't think you did accept the decision on the basis of what you already said here today, but I'll deal with that.
Well, read my email. I write to the National Director and say I've been removed. can he confirm that terminates my involvement? I do not write a long letter, but I've been wrongly removed and you must intervene and you're reneging, etc. I merely said, and I was upset to say that for no reason at all, because I'm a senior manager managing a difficult portfolio. I'd have expected a meeting to come in and say, look, this is why you are being removed. And I'd also expected to have had a fair opportunity to do a proper handover, because I said, we're giving you basically until tomorrow morning to have a handover report. So that's what I'm saying.
But Mr. MacAdam, it wasn't about you. As I read the situation, it was about in which division or portion of the NDPP or the National Prosecuting Authority the investigation should reside. It wasn't about you as an individual.
As a senior member of the NPA, and I've been a deputy director since 1998 when Anuka started, I've always accepted that there would be communication between top management and middle management, that if there is a key decision regarding a change of your portfolio, you're brought in, explained. So, I find it strange that you just hear from Ms. Johnson, who is a deputy director of the same rank as I am, that you're summary out of it. Because to my mind, that looked like I've done something terribly wrong. They could have axed me like you'd cut off a cancer in your finger. So that's what was my concern. Particularly as there had been this dialogue since June up to September, one-on-one meetings with the National Director, where he was of the view that I should continue.
But this couldn't have been a surprise, Mr. MacAdam. Can I take you to your affidavit in paragraphs? Can we start at paragraph 29 at page 6 of your affidavit? And I put it to you that the 1 October change in responsibility was the end of several months of ongoing discussions and activities within the bureaucracy of the NPA. Let's just start with paragraph 29. I again received messages via Advocate Mokgoro that I should hand over the foreign bribery portfolio to the SCCU. At that stage, Advocate Andrea Johnson was acting as the coordinator of the PCLU. She on more than one occasion told me it was a foregone conclusion that I would be removed from foreign bribery and that I should therefore concentrate on PCLU work.
Well, neither Advocate Mokgoro nor Advocate Johnson could make that decision. My appointment was given by the National Director. It was only the National Director who could revoke that delegation and assign me other duties. That's why I indicated that it would be important to have a meeting with the National Director so he could clarify the issue.
Then let's go to paragraph 32. That's now in July, the end of July. A meeting took place on 28 July 2015 with the NDTP, Advocate Mokgoro, Mr. Adam, and Advocate Mwebi, where these discussions were ongoing. I'm not going to read the whole thing out again, but in there it's also brought up that the file should go back to the SCCU.
And after a thorough debate, the National Director requested the other people to leave the meeting and to remain alone with him. We had a frank and honest discussion, which was to the fact that I should continue until further notice. The National Director could have said he agrees with what these other people say, and Chris, I'm relieving you of your duty, and then that would have been the end of the matter.
But I'm dealing now with your statement, Mr. MacAdam, earlier, that they removed you like cutting your finger off if it had cancer. And what I'm trying to show you is that this is an ongoing process that came about after several months of bureaucratic wrangling within the NPA, as happens in most large organizations.
The issue is I'd been appointed by the National Director. Only he could cancel that delegation. And despite these wranglings by Johnson and Mokgoro, the National Director was adamant to continue. So I would be in breach of my duty under my delegation to say, okay, I'm throwing in the towel, And then the National Director said, what are you doing? Why aren't you complying with my delegation?
Well, Mr. MacAdam, it appears you don't want to hear what I'm saying to you. I'm not saying that you should stop working. I'm dealing with your knowledge that this situation was not a surprise, that it was something that was on the table for some time. You do not wish to deal with what
I'm answering your question honestly, and that is that I was informed by two people they wanted me to give up the portfolio. There was the first meeting with the National Director where he said continue. There was a second meeting where he told me to continue. And then out of the blue, I'm told, you're immediately off, handover immediately. And then suddenly, 8 days later, here's an email from the National Director saying, I haven't cancelled your delegation, continue with your duties. In fact, go to Paris. That Paris trip alone, the airfare was 55,000 Rand. Why does the MPA waste 55,000 Rand to send a person to Paris when he's not actually the dedicated prosecutor?
Well, the answer is quite simple, Mr. MacAdam, because you had the knowledge of what had happened in the last year. Isn't that obvious?
No, that would be fair if he said, I'm cancelling your delegation, but I need you to be part of the delegation because of previous knowledge. But he made it clear he hasn't cancelled the delegation. And that was the concern. He said, go on. That's why then when I got back from Paris, went to the police and said, give me back my files. It's confirmed by the National Director I'm in charge. And when the police said, no, they're not giving me the files back because they've been redistributed, that resulted in me writing my letters to Advocate Pretoria to obtain the clarity of the National Director.
Is it the prerogative of only the National Director of Public Prosecutions as a manager of the NPA to move around people within the NPA? Can any other head of unit not make a decision like that?
The directors can make decisions regarding their staff. Special directors can, but we're dealing now with an authorization that had only been issued by the National Director. And the only way that that decision could be overruled by a Deputy National Director is if the National Director had appointed that deputy to act on his behalf and deal with the matter. There's a provision there where he can appoint a Deputy National to make a decision which actually rests with him.
Mr. MacAdam, I must say I'm going to suggest I'll deal with some further issues after lunch. I think we're almost at the lunch adjournment now, but just before we get there, I'm going to suggest to the inquiry that your real gripe here and your real complaint is that you were removed, and that has clouded and impacted on your entire view of the matter, and that you have come here because of your personal disagreement with what happened and your personal feeling of having been some way insulted or not appreciated. You can comment on that if you wish to.
I deny it emphatically, and I confirm that the only reason I am here today is at the request of the evidence leader.
Madam Chair, could we ask for the adjournment at this stage, just to try and go through what we still have to deal with? It'll save us time. And we can take the lunch adjournment now if possible. That would be in order. Subject obviously to anything you wish to do.
Can I ask one question?
Certainly.
I might forget it.
Yes, it is about lunchtime anyway, but we will give the panelists an opportunity to ask the question that you want to.
Just one small question. I just wanted to understand, Advocate Mokgoro, what was her designation?
She was a Deputy National Director of Public Prosecutions as well.
So she's same rank as you? Or?
Higher rank, same rank as Advocate Jiba.
Okay. Thank you. Are you going to continue with Advocate
Yes,
MacAdam
we
after
could
the-
continue after. I just want to just go through a few notes and try and see if we can wrap up quickly after the adjournment. Save time rather than tediously going through each and every aspect.
Perfect. Can we then adjourn for an hour? It's lunchtime. No, this time for an hour. I want to make those kind of requirements only. Not 20 minutes, 1 hour. So we resume at 2 o'clock. Thank you.
Yeah.